Good morning, everyone. Thank you for being here this morning. You've probably hopefully have heard a title of an old movie called Dirty Dozen. That was a ragtag group of World War II Army commandos, and they didn't follow any rules. They did it their way, and they violated all kinds of military protocol. And the lieutenant who was leading the team, he was always in trouble with the top brass. And it created a lot of chaos while they were trying to get this mission accomplished that they had. When you have managers who do this type of thing, lawsuits are going to be triggered from their action and their chaos that they create, and serious consequences for your company. So today we're going to talk about 12 of the worst manager mistakes that trigger these lawsuits and what we can do to prevent them. First, I'd like to talk about what the cost of these lawsuits involves. First of all, it involves a lot of time. It involves time for you to investigate what was going on. It involves time with lawyers, with courts, time to go to court or to attend hearings. This time is valuable, and taking a lot of time to go through this entire process costs a lot to the company. And this time not only involves 6 months or a year, it could drag on up to 5 years, depending on what the lawsuit is all about. Also involves a lot of money. You know, whether you lose in court or whether you win, you're still going to spend a lot of money. You got to pay fees to the attorneys, to the courts, sometimes settlements, maybe penalties. You could even have some punitive damages. And all of this can really negatively affect your bottom line. And of course, there's harm to the company. These kinds of lawsuits, they involve everybody, your employees, managers, etc., your customers, your vendors. People lose confidence in your management or in your company. And sometimes there's publicity involved. And this publicity, coupled with all of the time and money, this could have damaging effects that just can't be reversed. So let's talk about mistake number one, sloppy documentation. You know, today everyone uses emails and text messages, putting personal comments in these emails and text messages, inappropriate words, sending them out to individuals that really shouldn't have any business even receiving them can create a problem. Remember, this is a permanent record. Any good computer tech can get stuff back off of your server, even though the person thinks that they've deleted it. Also, written memos, written warnings, things like that, they're poorly written. They lack details. There's no backup data to go with them. Maybe, for instance, as an example, they were asked to describe the scene and what was going on, and they did it in 20 words. That certainly is not the kind of documentation you're going to need if you have to go to court. So how do we solve this mistake? Well, first of all, training. You're going to see throughout all these mistakes, training is one of the key factors in solving the problems that are created by all of these mistakes. You want to review documentation before it goes in the file. You want to address discriminatory intent or retaliatory actions or personal vendettas that maybe the manager has against the employee and is putting it in the documentation before it goes into the file. And you want to weigh assumptions or facts. I apologize, I went forward too quickly. How do you correct this mistake? Again, training. Do your managers know how to document? Review a file before it goes in and weigh the assumptions and the facts. Number two is not knowing policies or procedures. This is important. Ignorance on the part of the manager is no excuse. It causes confusion for the employees. They think they know what the policy is, but the manager is telling them something completely different. So there's a lot of errors that can accumulate, or maybe misinformation. A manager might maybe purposely violate a policy or a procedure. A shipping manager might say to their warehouse team, listen, we got to get this shipment out today. No ifs, ands, or buts about it. Forget about that policy about final inspections on those parts. Just pack them up and ship them out. These kinds of conflicts are created between managers and the company directives and could cause serious problems for you and even lawsuits. Increasing the company liability is something that you want to be sure that you're protective of. Mistake number 2, how do you correct this? Well, again, training your managers, letting them know what the policies and the procedures are. Create some levels of approval. The manager just doesn't have sole responsibility for something. Sometimes he needs an approval above him as a check and a balance to make sure that these policies and procedures are followed. You also want to involve HR in any decisions as far as policies and procedures. And perhaps you want to have an HR person or a senior manager once in a while attend different managers' meetings with their staff to find out what they're telling them and what they're saying a policy really means and what the procedures are. Sometimes they think they know what the policy and procedure is, but they're really off base about the whole thing. Mistake number 3, inflated appraisals. This is not the favorite thing for a lot of managers to do, but it's important that they do them. Inaccurate assessments of an employee can create problems at the time of a lawsuit because your files, they could be subpoenaed and what's in the files as well. If you're giving an inaccurate assessment of someone, giving them a rating of above average, for instance, but then when you read the appraisal, they've had all kinds of attendance problems and things like that. The music and the words don't seem to beginning to match. There's a lot of inconsistency in the appraisals. Sometimes managers aren't honest with employees in the appraisals. Maybe they're not doing a stellar job with a particular aspect of their job, but they're not being honest about it and they're just brushing it over because they just don't want to address it with them. Poor documentation as well. Explaining to an employee that they have horrible attendance and if they're out one more day, they're going to get fired, yet they don't show the employee any backup about their attendance. No timesheet records, no tracking of when they've been out. That can create problems for the manager when they're telling the person they could possibly be fired for attendance with no backup. Intimidation. A lot of managers are intimidated by their employees. Long-term employees that have been there a long time and they know everything. Employees who have very strong personalities. These types of situations are difficult for managers to handle sometimes when they're doing appraisals. They should certainly think about getting help when this happens. And correcting the mistakes that are made with these appraisals could include getting that proper documentation and examples that you need for your appraisal. You want to be honest with your evaluation, and it's tough, I understand that, but honesty is the best policy. And you know what? That employee wants you to be honest with them. They're not doing a good job, they want to know it, they want to know how to do better. And you want to be consistent. If you're giving somebody an above average rating, when you read through the appraisal, it should match up. You want to be prepared. Employees can tell if you wrote that appraisal 20 minutes before the appraisal meeting. You should be looking at the file maybe earlier in the week, getting your facts together, your documentation together, and thinking about the rating you want to give this employee, maybe looking at their previous rating to see if they've done their goals. And always consult with HR for assistance. That's why they're there. They're there to help you so that you don't make the mistakes that we were talking about earlier. And don't let a situation that happened yesterday, that was a very negative situation, overshadow an appraisal you're doing for someone that's going to cover the entire year of performance. Sometimes that's not fair. Managers sometimes shrug off complaints. They turn a blind eye. It's like a hear no evil, see no evil type thing. They make excuses as to why they're shrugging the complaint off. You know, babysitting is not in my job description, and I'm not going to do it. Oh, it's just that disgruntled employee again, making complaints about stuff. They're not just making complaints about stuff. They're probably causing a lot of consternation in their team as well. Correcting this mistake is a pretty simple way to handle this situation. Address the issue and don't turn a blind eye. It's not going to go away. It's going to be there, and if you don't handle it, it's going to get worse. Making excuses only jeopardizes your credibility. When you say to your team, oh, they're always grumping about something, the team looks at you and goes, yeah, but what are you going to do about it? We're sick of listening to it. You know, employees are a reflection of how you manage your team. And if you see it as babysitting, you're missing the entire mark. One of the great things that a manager can hear when they come back from a 2-week vacation is, man, I mean, your team just hummed along while you were gone and did a great job. That's a reflection on you. You know, failing to talk with a disgruntled employee is going to reflect on the company overall. And when you go to court, it's certainly going to reflect on the company as well as the manager who was managing the situation. Number 5 is the interviewing process. And making errors in an interview could cause a lawsuit. The person who came for the interview could be disgruntled and file a complaint that they weren't chosen because of some sort of discriminatory or retaliatory or situation that's not fair. If you have poor documentation notes, it's going to be hard to defend a case like this. Writing, just scratching notes on a resume is not considered proper documentation. Failing to evaluate how well this person would perform in the job. What kind of questions are you asking this person to find out if they really do the job well? And asking inappropriate and illegal questions is certainly something that's going to cause trouble in a lawsuit. We have a sheet that we could send you. On one side, it shows improper questions and illegal questions, and on the other side, it tells you the right way to ask these kinds of questions. Contact us if you would like to have that sheet, because correcting the mistakes in interviews is very important as far as lawsuits are concerned. Have your manager prepare interview questions and be consistent with all the candidates. Pull out the job description, make up the interview questions, and anybody that's applying for that job is going to get the same interview questions. Consistency. How could anybody complain about not being given a fair interview or something like that when all the people you interviewed were asked the same questions? Be able to explain why certain other candidates were rejected. By looking at your interview notes, everyone answered the same questions. It's an easy way to compare and find out which person had the better skills, the better education, knew more about the functions of the job, knew more about payroll processing than the other 2 candidates. Never ask about age, race, marital status. Have you got any kids? What are you going to do with your kids during the day? Because you've got to be here at work on time. Do you have a car that runs pretty good? What kind of car do you drive? Is that an appropriate question? And certainly not religion, how's their health, have you ever filed any workers' comp claims lately, or what their politics are all about. Mistake number 6 is changing your story. This comes about when you're making some sort of adverse employment decision. Maybe you're firing someone or disciplining them, or maybe you're demoting them. And what you're telling the person just isn't clear. And the reasons for your decisions then change if a lawsuit would come into play, or a situation would come up where you'd have to defend why you made those employment decisions and what you told the employee. The company loses a lot of credibility with courts and also with juries when you change your story. So how do you correct this mistake? First of all, don't sugarcoat your critiques. Be honest when you tell these people why they're being demoted or why they're being fired. Be straight with them from the very, very start. Again, honesty is the best policy with employees. We're terminating you for attendance. Here's your job record as far as attendance. And as you can see, it's very poor and it's affecting the whole production line. So for that, we're going to terminate you. So be sure you do things right from the start and ask your HR department for help. And again, be consistent. The reasons that you document and the reasons you tell the person should always match up. Number 7, papering an employee file. What's this all about? This is over documenting. This is when you document in a rush right before an employment action. If you're going to terminate somebody or demote them, you want to prepare for that. You're not going to do it today because the meeting is tomorrow at 9. You run around and hunt through stuff and start digging for documentations to load up the file so you've got plenty of documentation on this person. That's not the appropriate way to do it. And the courts can see through all this rush action as well. They're pretty smart, and so are those juries that are sitting there listening to all the evidence against the company. Correcting mistake number 7. Again, we talk about that same old word, being consistent. You always want to follow the right process. If you're consistent in what you do, it's going to keep you and your managers on the straight and narrow as far as making mistakes that cause lawsuits. You want to document positive and negative behavior. Only documenting negative behavior doesn't look well on the manager. It might appear he's looking for mistakes on this person, or maybe over documenting the file because they have plans to terminate the person down the line. If a person did something positive, they should be rewarded for it. Keep a performance log, perhaps. And with the log, there are the dates and the items backed up with documentation and whatever, whether it's good or whether it's bad. It's great to use at performance appraisal time. You don't spend a lot of time hunting for stuff. You're all ready for the appraisal because you've been keeping your log all year long. It also helps for the reverse. If the person is falling down and not doing their job and you're keeping a performance log, comes time for termination, the manager has a much easier job of putting everything together for the employee. Mistake number 8, being rude and mean-spirited. The key supervisor, he's rude, she's rude. They're insensitive and they're mean. This old type of supervision is a ticket to court. The best case can be damaged in front of a jury when a person like this gets on the stand to defend what they've done. This is a big mistake, and companies need to be observant. And when they realize they've got supervisors who are using this kind of behavior to manage their teams, This is something you need to jump on right away. You want to always remind your staff and your managers. The same old golden rule always applies, even in the employment world and at the workplace. Employees want to be treated the same way the managers want to be treated. If they want the manager to be fair with them and to be honest with them. The golden rule contains not only being fair, but compassionate and generous and friendly and helpful, guiding people, being considerate, being helpful. And that goes both ways, of course. That applies to employees, but certainly to the managers. This is a pretty major mistake. Careless statements to officials. If the EEOC, the Employment Opportunity Commission, or the Department of Fair Employment and Housing, or OSHA, or any of these local, state, or federal agencies call you or come to your workplace for a visit, when they see inconsistent documentation, when they see poorly written affidavits that they might have requested, or ill-prepared statements that they are looking for from people, these can get you into serious trouble with these officials. And this is an area where you need professional help from professional HR, help from someone like CalWork Safety to get you through these kinds of situations. You can correct this mistake by keeping all your information consistent. If they come in for an audit, they're going to want to see that you've crossed your T's and that you've dotted your I's. You never want to change your story with these folks. It is what it is. Always seek assistance from HR or legal, because this can be a serious mistake for you and could certainly create some lawsuits and some legal implications for you that you're going to find very difficult to deal with. Again, consult with us, consult with CalWork Safety if you ever get letters or calls about visits from any kinds of agencies, whether it's state, federal, or just local. Mistake number 10, this is a lack of legal knowledge. Managers are uninformed about the laws and the regulations. Well, I didn't know there was a rule about giving people breaks. What do you mean they got to have a 10-minute break in the morning and in the afternoon? Ignorance of the law is no excuse. And you'll quickly find this out if you get involved with lawsuits containing anything about the laws and regulations, especially wage and hour and other serious implications regarding OSHA regulations and safety violations. Sometimes management violates laws and they know they're violating them. Talking about safety, a warehouse manager knows the law about forklift drivers wearing seatbelts. They should have the seatbelt on when they're driving that forklift. But he's got a group of great guys. They have fun. He really enjoys them. And they always grump and complain that seatbelt on the forklift, I don't need that on, I'm careful. And the manager says, well, yeah, you're probably right. And so he doesn't enforce the seatbelt law on the forklift. And sure enough, somebody gets injured. This manager is as guilty as the employees are about the seatbelt and not wearing it on the forklift. Your handbook, your policies, and your procedures are not current. Maybe you don't have the current rules in your handbooks about wage and hour and other types of regulations that employees or employers have to deal with. Again, we can certainly help you with this. That's our job. You want to review your policies and procedures and handbooks. We always call you and remind you, hey, it's coming up on the first of the year. We need to review your handbook and get you a new updated version. There's been a lot of law changes. Don Dressler has an annual update about all of the new laws and regulations that are coming out for the new year. Make sure you attend his webinar because it's always very informative and helps you stay apprised of what's going on out there. You want to update your managers too. There's a lot of laws that change and a lot of regulations that change, and it's tough to try to keep up on this stuff by yourself. And it's really tough for your managers because after all, they're worried about their team, they're worried about their production, they're worried about what they are supposed to be doing to keep the company afloat. And sometimes they forget about these other aspects of laws and regulations that are out there, and reminders about policies and procedures when they come up. You want to discipline your manager when there are violations, like this warehouse manager. He should be written up as well, not just the employees. They were all violating that OSHA regulation and they should all be disciplined for it. Number 11 is dictating accommodations. Accommodations are a very important aspect when you're on a work comp leave or if you're on just a general leave of medical general leave of absence. Managers sometimes decide that they're going to make the decisions on whether accommodations are going to fit their needs, not the employee's needs. And sometimes they can be obstinate and negative about it too. And this can create serious liability for the company and could also create some lawsuits. How do you deal with these managers who want to take this responsibility on themselves? Well, first of all, accommodations should always be reviewed by senior management and by HR. Letting your supervisors, lead people, or lower level managers decide whether or not they're going to give an accommodation can sometimes get you into legal trouble. Either they don't want to do it, they make the wrong decisions. So always involve upper level individuals in these kinds of situations. Decisions have to be compliant with some federal and state regulations. This is another reason that you need to bump this up to the next level when you're talking about accommodations. Americans with Disability Act, Equal Employment Opportunity, Fair Employment and Housing, they're all involved in these situations where accommodations are to be talked about with a comp leave or a medical leave of absence, FMLA, CFRA, and et cetera. The whole idea of these accommodations is that you want to get the person back to work. That's the whole idea. Getting people back to work is important. It makes the employee feel better. They're back at work. They're getting into the mode of doing their job again. Their team is there to help them and give them support. So giving accommodations is an important factor when talking with folks who have been out on these leaves. There's another aspect that you must do, and that's the interactive process. The interactive process tells you, as part of regulations, that you talk with the employee, have a meeting with them, discuss what the accommodations are, look at the restrictions that the doctor is putting them on, and how can you accommodate them so they could come back into work. Maybe they have to take a break every hour. Maybe they can only work part-time. Whatever the accommodations are and whatever the restrictions are, it's important that you try to work within them and get that person back to work. It's good for everyone, plus it's part of the regulations that we have to adapt to. Number 12, firing too fast. Sometimes managers get frustrated. We understand that. The employee isn't listening to them. They're not improving and they're done with them. I've talked to them. Oh, I think I talked to them yesterday about it again. I'm really upset. I'm firing them this afternoon, get their final check ready. That certainly displays insensitivity. A workplace where this is the norm rather than the exception, it's pretty well known in the company that if you don't do your job, there's not going to be a series of performance reviews or corrections or whatever. They're just going to fire you. That creates a lot of turnover. The employees have a bad view of the company. Anything you do in haste makes waste. It also creates potential discriminatory action, and certainly lawsuits follow. So how do you solve this situation? First of all, you want to take steps to improve the performance of the person. Yes, it takes time, it takes documentation, but it's important that you do it to protect the company's liability and to make sure you're being fair to the employee as well. You want to demonstrate your concern and your assistance to improve performance too. You don't just give the person an improvement plan and say, here, you got to get all of this done by next week. That doesn't show that you're really concerned about the person. You sit down with them, you talk to them about their performance, and what are we going to do to improve? That's the whole idea. You want to avoid a lawsuit by trying to improve the person first. Maybe the person doesn't make it, and maybe the person is terminated. However, you can feel that you did your best, you tried to get the person to improve. And any court or any jury is going to see that by your actions before you did a firing. So those are the 12 mistakes that managers make. Sometimes they don't even realize they're making them, maybe, or maybe in their defense, nobody's really given them any training. They just kind of manage by the seat of their pants, I guess. But it's important. And training. I can't emphasize that more. And also CalWorks Safety, if you go to our website, we have a long list of training programs that we would be happy to work with you and present to your staff and to your management staff. Please be sure and give us a call. Remind you that lawsuits can be reduced. We can stop this snowball. Most lawsuits, they're not triggered by great injustices like these big lawsuits we see on the front page. Instead, they're usually simple management mistakes, perceived slights. It'll start that snowball of discontent rolling downhill, and it rolls right on into the courtroom. Thank you.
All right, so we just have a couple questions. If we don't do appraisals at all, is that a potential flag for these lawsuits?
If you don't do appraisals at all, it seems to me that it would be tough to defend a termination. It would be tough to defend a demotion because you have no backup. You have no documentation to show that the person's performance has deteriorated. Their performance in this appraisal last year was great. Look at it this year, they've fallen down here, they've fallen down there. I think appraisals are very important. Employees want to hear how they're doing. How would you like to sit at a desk for 2 years and no one ever came up to you and said, hey, let's sit down and talk about how you're doing? So to me, I think appraisals are very important. Employees stay informed. Managers are pretty much forced to show that they are managing this person. They know what they're doing, what they're not doing, and what they should be doing. So I strongly encourage performance appraisals.
Can we ask, do you have your own transportation during the interview?
I like the question, you know, your job starts at 8 and it ends at 4:30. We value good attendance here. It's very important. It's an important part of your job. Are you able to be here at 8? And of course, you'll go home at 4:30. And will you be able to be here every day and be on time? Maybe they take the bus, maybe they take the train. It's their business how they get to work, but it's your business that they're there at 8 o'clock every morning.
Over documenting, could emails or text be a part of documenting to be as a warning, or discipline be used?
A lot of times you're working with people off site. Sometimes emails are a good way to communicate with the employee. I like to remind people that emails, texts, they can be subpoenaed. Normally, a written disciplinary form is a better way to do it, but you could certainly email that to the employee because it's important that the employee acknowledge that they've gotten the disciplinary or written warning that you are giving to them. But using email it is a helpful way, especially when they're not on site with you. If they're right there in the building with you, I recommend you sit down with the person face to face and talk to them. That way the employee sees it, you're sincere, you're honest, show that you have concerns for them, you're worried that they're not performing, and how can I help you?
Do I need to say why being termed if he or she did not pass intro period?
If they didn't pass the intro period? Yes, you should certainly tell the person why they're being fired or terminated from their job. The introductory period is a time for you to evaluate the person. The person evaluates the company. If you see that they're just not measuring up to what their expectations were with 90 days, you certainly have the right to let them go at that point, but it's fair to the employee to know what happened and why I'm not going to make it through my 90 days.
In California, is it legal to verify previous employment prior to extending an employment offer?
You can certainly check reference and ask them. A lot of times employees give you references to check. Sometimes the employee will tell you that they don't want you calling their previous employer. Therefore, you're not going to be able to do that. But certainly doing most applications, all applications, I'll revise that, all applications should have a documented statement on that application that says, I know that I will be having background checks done, et cetera, and they approve that so that you can send out a background check to check on the person's previous employment, their education, et cetera.
How to handle an employee who has been injured on the job, has been to the clinic for treatment and is on light duty, but won't comply with the limitations set up by the clinic/injury activity status orders with regard to push-pull-lift limitations?
I'd like to refer that to Don Dressler because he's our comp expert. And I use him for counsel on work comp all the time. Don, would you like to respond?
So anytime a employee doesn't feel he can comply with the work restrictions from his treating doctor, we're not doctors, so we're not trying to evaluate whether the restrictions are correct or not. He either performs the work that the doctor says he can, or he goes back to the doctor to get a correction or a change in the work release. Because otherwise, it's a failure to perform duties as he's hired. California does have a concept called the duty of loyalty, meaning you take our pay, you follow our directions. So you have to be careful that you know that there may be a disability because they're saying that. Also, don't forget the potential that you may and probably do need to engage in an interactive process with the person to discuss the limitations he has in his ability to perform the essential functions of his job. So don't let him just make these comments of I can't do it or don't want to, or I have pain. And I'm handling some cases like that right now. Either they do the work the doctor says or they go back to the doctor to get a correction. And you can rely on what the doctor says and demand that they bring a doctor's work release when they return to work, or they can't return to work without bringing a copy of that release. That saves you the trouble of finding it or running down the doctor or getting it. It's simply they must bring it because they can get it every time they're at the doctor's office at the conclusion of their visit.
So if it's the other way, they do more than they're supposed to on the injury thing.
Then if you know that's a potential, then you need to sit down and say, what are the limitations that you have in doing this work? If they tell you, hey, I don't have any limitations, I feel fine, I'd sure want to make a note of that. I don't think that we're in the business of policing their work restrictions, but also can't ignore it. So there must be something going on if they're working beyond those restrictions. And it's possible they haven't been honest with their treating doctor. The treating doctor's statement may not be correct, but you shouldn't just ignore the situation because otherwise you may be having the employee perform an unsafe act, and that could be a violation of OSHA.
Okay, so isn't California an at-will state? Can't an employer fire an employee without any reason, without cause? If this is true, why does documentation matter?
Pat, I'll jump in. We can fire a person for any reason except an unlawful reason. So the reason for all this documentation is to show that you are complying with the law. I did want to add one other comment about background checks. There's a difference between credit checks, criminal history checks, and background checks. You can do a reference check while you're deciding whether to extend an offer. You do not have to have what we call a post-offer pre-employment situation. Under California law, when it comes to doing criminal checks, credit checks, which can only be done on certain occupations, those are the type of things that need to be done after you've decided to hire someone, but you have a condition to verify some things before they actually are allowed to start work. But calling a former employer or references they give you is not a background check that's restricted by California law or federal law.
Our employment app stated we may conduct post-offer pre-employment background checks, including criminal background checks. Are we legally allowed to verify previous employment prior to employment offer if the applicant marks box okay to contact?
If you're contacting prior employers, that's a lawful reference check. It technically isn't a background check under the Fair Credit Reporting Act, which is what part of the laws apply to, or the criminal history laws that apply. It's a reference check, and you can do reference checks.
All right, do we have any more questions? All right, I think that's all we have. Thank you so much, Pat, for sharing. This is an important topic, and remember, if we didn't address your question today, go ahead and reach out to us. As a reminder, CalWorks Safety and HR is dedicated to helping businesses remain compliant and successful during the COVID-19 pandemic. Please be on the lookout for future topics on our website at calworksafetyhr.com. Thank you for joining us. Stay safe, healthy, and have a wonderful day.
Thank you.